So we are recording this session so that if you are interested in looking back at it, you can do so. Please just reach out to us and we will share a link with you. So just a few sort of housekeeping rules to get us started. So we will enable the Q&A box. So if you do have any questions, please do put them in there and we will endeavour to answer them at the end of the session. And afterwards, from the chat perspective, we are also enabling the chat. Please don't put questions in there because we probably won't see them. This is something we're going to use during the TUPE case study. So use it then, but try not to use it before then. We'll also be using Mentimeter, which is an online survey tool. We'll give you some more guidance on that when we get to it, but just have your phone ready or a web browser so that you can join into some of the questions, and that will be fab. And then on the slides, so we're not intending to send out the slides, but you can take screenshots of specific slides if you want to, because some of them do have quite a lot of content on it, particularly some of the legal ones. So you might want to refer back later. So just going to briefly go through the agenda. So we move on to that. So we will start off with some definitions, and then we are going to go through quite a few sort of legal elements of the transfer and consultation process, but also some practical tips to manage, particularly on a global multi-jurisdictional basis. And we also have a TUPE deep dive and case study, which Rebecca will be leading us through. So just in terms of introductions, if you haven't attended one of these before and you don't know me, my name's Helen Carney. I lead our M&A people practice here in Deloitte UK. And I focus and specialise in supporting HR functions through mergers, acquisitions, divestitures and all manner of other things. And I will just hand over to Rebecca to introduce herself as well.
Hello, everyone. Yes, so I'm Rebecca Butler. I'm a director in Deloitte Legal in the employment team there, and I've got over 14 years experience of all aspects of the employment lifecycle, but with a particular interest on people and M&A. Over to you, Megan.
Thanks, Rebecca. Hello, my name's Megan Sharp. I'm in Helen's team, so in people M&A, and a HR M&A specialist, working with clients on large multi-jurisdictions transactions, and I work across a variety of sectors.
Thank you very much. So as I mentioned, we're going to kick off with some definitions. So over to you, Megan.
Thanks, Helen. Okay, so we're going to start by taking a look at what we mean by transfers and the consultation process. So employee transition is the journey or process of moving people from their existing role to a role in a new organisation design and or a new legal entity. In some situations, in order to proceed with the employee transitions, employees will have a statutory or legal right to be either advised or consulted on the changes that are impacting them. Examples of changes could include changes to their employment terms and conditions, a change in their working location, or changes to the structure of the organisation they will work in, to name just a few. On the right-hand side, we've got an example of what the typical employee journey through people transition and consultation might look like. Typically, there will be some form of initial announcement. This will be relatively high level, sharing information on strategy or the business intention. For example, a business may announce their intention to explore separating or selling a subset of their business. Following this, a buyer may be announced for the business. And then following that, the start of a consultation would commence, and this is where a formal process would be kicked off with the employees. Further information will be shared on what the future looks like over the next weeks and months, and that will be shared with employees on the lead up to the deal completion or a day one. And then on a day one, the actual transaction occurs, and the employees now have either a new employer or a new leadership team that is in place. So clearly there are a lot of changes and information to absorb for employees going through this journey, and it is incredibly essential that business get this process right. I will now pass over to Helen, I believe, for Menti.
That's right, thank you. So just before we get into the kind of detail around the different employee transfer approaches and mechanisms, etc., I just wanted to get some feedback from you using Menti. So if you could go onto your web browser, either through your phone or your laptop or whatever, go to menti.com. There's a code there, 87690350. If you go into that, and then if you could provide any details of any employee transfer issues that you've encountered on previous deals, just be really interested to hear your thoughts. So let's wait a moment and see those come through. So I think from my experience, some of those issues have been around sort of things like works council negotiations going wrong, things changing, managers changing their minds about things. That often happens. And here we can see some of your, oh, we've moved on to the next question somehow, the wrong question. Right, sorry, if you refresh your screen, you should be able to see this question now. So what employee transfer issues have you encountered on previous deals? So please do, it's free text, so you can put in whatever you like. Changes to terms and conditions, yeah, that can create significant issues in terms of transfers, because that can make employees not wanting to transfer or certainly being challenging employee rep bodies. Yeah, absolutely. Lack of information available, absolutely, always a difficult issue. Yeah, culture as well. Timing of the deal, yes, I think works council expectations are always difficult to meet, and then sort of aligning those works council expectations with the overall deal team is very difficult. Fab, that's great. Thanks so much for thinking about that and for providing your responses. Going to move over now to Rebecca, and she's going to talk through some of the employee transfer requirements and deal structures.
Thanks, Helen. Yes, so I'm going to talk you through an overview of employee transfer requirements, and you'll see as we move through the next couple of slides, sorry, if we could flick on, please, these are quite a detailed slides, so do feel free to take a screenshot for your reference. As we go through, you'll see that ultimately there is no one size fits all, as the employee transfer requirements very much depend on the deal and the other factors such as what is changing. But one of the first things we have to consider is whether the transaction type is an asset or a share purchase. Now, I see from the share purchase set out in the top row on this slide that the default position is the identity of the target company remains the same both before and after the sale, and it's simply ownership of the target that changes. And so the employing entity remains the same and the employees remain where they are. But depending on the market or the jurisdiction, you may also have to consult with works councils or unions and inform employee representatives or potentially even the employees directly. But the key thing is the terms of employment should remain materially the same. Whereas on an asset purchase, which is the below one, the second one, employees are automatically transferred so that they become employed by the buyer. Now, in the UK, we know and probably definitely don't love the TUPE regulations, known as the Transfer of Undertakings Protection of Employment Regulations 2006, and they're obviously derived from the EU Acquired Rights Directive, the ARD. And countries in Europe have, their own national legislation implementing the ARD, which is similar to, but not always the same as TUPE. Equally, some countries outside Europe, such as Chile, Argentina, Brazil, to name a few, they have their own rules about automatic transfer of employment and succession of the employer. Now let's look a little bit more closely at what TUPE actually does. And it provides that where there's a transfer of assets amounting to an economic entity which retains its identity, that means that any of the transferor's employers who are assigned to that economic entity will transfer with it. So the TUPE transfer doesn't affect employees' statutory rights. It has the effect that their period of continuous employment will be unbroken, with their terms of employment remaining materially the same again. And often the key question is, well, who actually transfers? Now, this isn't an exact science, but often employees with 50% or more bandwidth supporting the transferring business may typically qualify as an automatic transfer, but it does very much depend on the specific factual circumstances and should always be subject to a detailed legal and HR review to assess exactly who is and isn't in scope to transfer. So again, employees transfer on their existing terms and conditions, and that means that their rights and liabilities also transfer to the buyer, and that has important ramifications for the process and the deal documentation, which is obviously often heavily negotiated. As I've alluded to already, different jurisdictions will have different types of employee transfer mechanisms. Now, we have included a summary of the different transaction types and transfer options, as well as the impact of these on notification on these slides. So, for example, at the bottom of this slide, we've got LATAM, where there's employer substitution. But if we can flick to the next page, please, and again, feel free to screenshot if you'd like to take a copy of the detail, we can see yet more employee transfer mechanisms. So we have jurisdictions which don't recognise the principle of automatic transfer, such as the United States, Hong Kong and India, where there's typically a dismissal and re-engagement style process, or termination and rehire, or fire and rehire, shown in the second row here. And that's where the seller terminates the employment of the individual and they're offered fresh terms of employment with the buyer. And if the employee doesn't accept the new offer, then they may be entitled to severance, although note that, implications do vary by country and indeed by offer. So I think the main thing that we wanted to show from these two slides are just how different, the detail of the different types of employee transfer mechanisms are, to help illustrate the complexity of employee transfer requirements and the resulting difference in the type of notifications required. And really the key message that I wanted to end on for this section is, as the employee transfer requirements depend on the deal structure, legal advice should be sought as early as possible, really, regarding the transfer type relevant to the jurisdiction and deal structure, so that a strategy can be created and implemented with the relevant stakeholders in the business. And with that, I'd like to pass you back to Megan to look at the key players you might have to inform and consult with on a transaction.
Thank you, Rebecca. So as Rebecca mentioned, there are a number of key players a business may need to interact with as part of a consultation process in a transaction or business deal. They can include European Works Councils, local works councils, trade unions, and employee representative bodies. The employee representative bodies that you may need to interact with will depend on the organisation itself and also the jurisdictions in which the transaction is impacting. In terms of how those interactions might look through a transaction, they may be formal or informal. They will need to meet legal requirements in regards to information and notification sharing, but it will also need to consider legal requirements, custom and practice, particularly including what you've done before with employee representative bodies, what the employee representative groups are expecting, linking back to the first point, and how that relationship with the group is working. It may be positive, it might be challenging, maybe it's constructive. However that relationship will impact how you go about interacting with the employee representative bodies that you are required to work with. On a practical note, you'll be expected to facilitate meetings as part of the process and also obtain opinions and agreements where that is legally required. Looking at what employers might need to share as part of the information and consultation process, again, this really will vary between each deal and transaction, but it can include information on the potential impact on employment, such as the transfer of the employment, any changes to terms and conditions, and also any relevant information on potential redundancies as a result of the transaction. With that, I will now pass back over to Helen for another Menti.
And you've already seen this, Menti, so there's no surprises about what the question is. Which is, how would you describe your relationships with work councils and employee rep bodies? So as Megan said, sometimes these are constructive, sometimes these are a bit challenging. It all depends on that history. So really interested to hear what the overall sense is within the group that we have today. So it's great to see that we're mostly on the highly productive and collaborative side at the moment. Anyway, let's see if it changes. But yeah, I think you're probably going to be somewhere in the middle, depending. But it's great to say that it's great to see that there's nobody saying it's unproductive and difficult. That's really, really good. Fab. So now we're going to talk a little bit about global differences that we see in the employee consultation and information processes. So I'm going to pass back over to Megan, who's going to give a bit of an overview.
So complexity does differ across jurisdictions, and this is driven by the requirement to consult or inform and the local processes that are required to be followed. A number of factors can increase the complexity that we experience going through a deal, and this can include particularly scenarios where we have multiple jurisdictions to consider. In these situations, timing and sequencing need to be heavily and carefully planned through and considered, and then mapped out, because this will have an impact on timelines and what we're actually able to do as we go through implementing changes. The number of employees in a jurisdiction and the number of employees impacted within a given jurisdiction can also increase complexity. An example of that would be France, for example, is a relatively complex country to operate in from an employment perspective. However, if in a transaction we have only 3 employees in France, the level of risk and complexity that we would kind of focus and consider for France would be relatively reduced versus were there 1,000 employees undergoing the change. A final point to consider there is around operating in jurisdictions where there is a requirement to make severance payments. Where this is in place and required, that may also increase complexity and sometimes timeframes. But it is a combination of these factors, and from that combination that we form a view of the level of complexity in terms of working across different jurisdictions. Typically, we see the development of a complexity matrix to identify hotspots and almost create like a cheat sheet of the different processes by jurisdiction. So the example on the slide here is a good visual of something we would typically look at, and this is showing the complexity across Europe. It's also including key steps from a process perspective, any key call-outs on timings of when activities must start by or how long they might be expected to take, and also some key watch-outs. And then you can see here we've also got a red, amber, green for the complexity of those countries given the process and the above factors. But in summary, the complexity really does vary by jurisdiction. It's particularly heightened if we're working across multiple jurisdictions, but understanding the approach in each market and starting to plan early in the process is essential. I will now pass on to Rebecca to take us through a case study.
Thanks for that, Megan. Yes, if you can flick on to the next slide, please. Yeah, we're going to talk you through our TUPE case study. I would comment that the TUPE case study that we've put together is quite ambitious and complicated case study to cover in the time we have. So, and it's designed to get you thinking about the types of issues that can crop up in a TUPE situation, as opposed to being able to cover every single one of them, perhaps in great detail. But what we'd really like to do is include you at times throughout the case study as we go through it. And because TUPE is fact specific, I would suggest that you take a picture of the background stages to stainless steel and next gen robotics limited as we go through the facts. And with that, Helen, if you could please take us through on the next 2 slides, please.
Yeah, No problem. So as Rebecca said, you might want to take a screenshot because you probably will forget some of this information and want to have a look at it later when we go through the questions about the case study. So here we have Stainless Steel Limited. They are a UK-based company. Its main business is the production of steel at 2 sites, one named Ironside and the other one called Alloy. At Alloy, it also has an R&D function, and they're involved in robotics, and the 2 sites are about 20 miles apart. So Stainless has a large support department that provides HR, accounts and IT support services to the whole business, and they're based at the head office at the Ironside site, so alongside the steel production employees mostly. All the employees are employed through a group service company called Carbon Limited. So the workforce involved in steel production at both sites are unionised, and they have a generous redundancy scheme. The robotics employees are not unionised, so those are the ones at Alloy. They are not unionised, and they receive a less generous redundancy package. And while they're paid more than those stainless steel production employees, they are unhappy with their pay. So a handful of the robotics staff met with the Stainless management at the end of last year to complain about their pay. The company Stainless refused to increase their salaries, but they did agree to extend the generous redundancy package to them. And they also created a work canteen at the Alloy site, so the site where the R&D robotics employees are based. And that was following a consultation with a specially created staff body to consult on these issues. So despite the fact that they'd increased the enhanced redundancy payment and given them a work canteen, Stainless was very surprised that 5 key robotics staff recently left for a competitor business. However, there was Mr. Smith, who has almost completed a very promising robotic product, and he is still employed by the company. The business is heavily in debt, and there was a recent redundancy program, but that failed to stem any losses. So now Stainless have decided to sell the Alloy site. So we turn to the next slide and we'll just talk about the potential acquirer of that Alloy site, which is a company called Next Gen Robotics Limited. So they're a company involved in some cutting edge robotics and 3D design of innovative products. It is doing very well and it wants to expand. It's recently bought larger premises which still have some capacity, and its workforce has some limited capacity to take on more work. So Next Gen Robotics remuneration package is heavily weighted in favour of performance-related pay, and that's greatly increased the efficiency that it has, and it's also significantly lowered its costs. So it would naturally therefore be keen to apply this to any acquired staff. So as I said, it's considering acquiring Stainless's Alloy site, and Next Gen Robotics factory is about 20 miles from the Alloy site and then 40 miles from the Ironside site. In terms of timeline, exchange of contracts is planned for the 30th of September and completion is expected to take place on the 1st of November. Fab, hopefully you got all that. There's a lot in there. So let's move to the next slide. We're just going to go through some questions. So the first question we're going to look at is, will TUPE apply? So using the chat bot, the chat box, please could you put in a yes or a no? So yes if you do think TUPE applies, no if you don't, and we'll just wait for some of these. And it's not a test, nothing's going to happen if you don't get it right, so don't worry if not. But have a think, do you think that TUPE applies in this scenario? Getting some answers through. So Rebecca, we won't wait for all of the responses to come back. What would you say?
The answer is, as some people have already commented, that yes, a transfer of part of the business can be a TUPE transfer, provided it is capable of being a separate economic entity.
So Rebecca, what is being transferred, and is the robotics function capable of being a separate economic entity?
Well, to assess that, we'd need to look at factors such as the cost centre, separate management and premises, the robotics part of Stainless's business seems to be a distinct part, but what about the steel production at the alloy site? So the key question is, we have to consider whether whatever is transferring retains its identity post-transfer. And so, yeah, that involves whether the key constituents of its business are transferred. So it will depend on the terms of the ultimate deal about premises, license, staff and equipment, etc.
And so moving on to the next question. So will it be integrated into next gen robotics?
Well, again, we'll have to look at where exactly the business and the employees are going to be transferred into. You know, will they be integrated with NextGen's robotics, pre-existing robotics business, or would they sort of stand alongside as a bit of a bolt-on? If it's the former, then there may be an argument that it's failed to retain its identity, although there is, you know, ECJ case law which suggests that a transfer will not be prevented simply because the buyer decides to carry out a structural reorganisation. So, yeah.
And we talked about different sales structures. So would a different sales structure be appropriate here, do you think?
There is another option that they could consider. So they could consider whether a share sale of alloy would be appropriate. I mean, they'd have to think about what that would mean in terms of reorganisations. So they might need to move the steel employees at the Ironside site, you know, and possibly even the alloy site as well. They may also need to consider whether they'd have to move support staff into another service company or Stainless itself, and what effect that would have on the consequent information and consultation process. But for today's purposes, let's assume the parties want to agree an asset sale and that it's a TUPE transfer of the robotics business. And then it would be a matter for negotiation as to what would happen with regard to the steel employees at the alloy site.
Okay, so let's move on to the information and consultation stuff. So which employees should be consulted with in this scenario?
Yeah, well, this is a good one, and hopefully you'll remember the facts, which are Stainless's alloy site employees. There does seem to be a union in relation to the steel employees, but not the robotics employees. And there's a query over, you know, the head office staff and whether they have a union or not. But the general rule is you must use your union representative if there is one for any particular category of affected employees. And if some categories don't have a union representative, then you either need, you know, existing appropriate staff body to consult with or to provide for elections for employee reps.
And you may remember that there was an employee body that was consulted with around that staff canteen proposal that that got accepted. So what do we think that is an appropriate body to be able to consult with on this? So keen again to get thoughts from the audience. Do you think that they could just consult again with that that body that they consulted on for the staff canteen, or do you think a new body would need to be established? So yes or no? Yes, we can consult with them. No, we would need to establish a new staff body. Getting some answers in now. So Rebecca, what would you say?
Yeah, so the parties will obviously need to consider what the constitution and the time period that any representative body is elected for and whether they have been appropriately elected. And there is a question mark over the staff canteen body and whether it is appropriate. Now, BIS guidance has stated that if they are to be appropriate, if they are existing representatives, then you know, their remit and their method of election or appointment must give them suitable authority from the employees concerned. And you know, it also goes on to say it may well be appropriate to inform and consult a fairly elected or appointed committee of employees, such as a works council, that is regularly informed or consulted more generally about the business's financial position and personnel matters. Now here, the staff canteen body was set up for a specific purpose, and you know, we don't have any other information about whatever else it may have been set up for, so we can only go on the facts. And if we turn to some ACAS guidance about handling a TUPE transfer, which suggests that they might be, if they had an appropriate appropriate training. But where we've got the staff canteen body which hasn't been appointed or elected, and it doesn't have any authority to represent employees on matters affecting employee contracts, I don't think it would be appropriate, even with training, to use this body.
Perhaps so most of our audience were right, which is good to hear. So will both companies need to consult with their staff on this proposed transaction?
Well, here we very much need to think about what Stainless and NextGen might be considering, because they will have separate obligations depending on what they're doing. So, for example, if they're proposing measures or changes to terms and conditions regarding their own employees, then they will have a consultation duty. Otherwise, they may just be in a position where they're informing about the situation. And in terms of what measures there could be, Stainless could have measures involving reassignment of head office staff. There could be redundancies of alloy site, steel employees, perhaps even head office staff could be affected. And NextGen Robotics may, depending on what it decides, have measures which impact on its own existing robotic staff. And in addition, obviously, if Stainless may have to inform transferring employees about NextGen Robotics measures affecting the transferring staff, albeit they have no strict obligation to consult on those, but they would have to inform on them. And of course, it may be that Stainless and NextGen want to agree a joint consultation process depending on the circumstances.
Okay. And then moving on to the all-important question of timing, which is probably our most asked question at when we're dealing with transactions. So we saw in the facts that contracts were due to be exchanged on the 30th of September, and then completion was proposed for the 1st of November. Do you think that's sufficient time to deal with the consultation process?
It is quite a short time between exchange and completion, and the answer is it may need extending depending on what parties are going to do, because the duration of the information and consultation process depends on whether there's a need to elect representatives, and importantly, what measures are going to be proposed by NextGen Robotics. So if there's redundancies or detrimental changes to terms and conditions, then that would likely lengthen the process. But if there are no measures, then the process could be a lot shorter, up to a couple of weeks, depending on if representatives need to be elected. But certainly if there are more controversial measures, then it could take a bit longer, particularly as well if NextGen Robotics are in a situation where they're planning collective redundancies, then Stainless would need to consider whether to agree to an information and consultation process on that which started pre-transfer. So often what we see in these types of circumstances is that the parties can agree like a time, facilities and accommodation agreement which covers assistance and cooperation with the parties. And that can include things like access to representatives, who bears the cost of the process, sharing information about the process. On the flip side, confidentiality and data protection terms, non-poaching terms. It could also include things like apportionment, although we've always got to be careful about making sure there's no conflict between this agreement and the terms of any asset sale agreement. So yes, really NextGen Robotics will need to think about whether it can complete any collective part of the process pre-transfer, and if not, how would that work?
So now we're going to move on to the issues around that NextGen Robotics would need to be thinking about. So we heard about some of those staff departures. So what issues might arise from having lost some of those staff recently?
Sorry, excuse me. Well, we'd need to consider whether we might need assignment of any of the restrictive covenants. So we'd have to look whether they were even assignable, or if they were enforceable. To do that, we'd obviously want disclosure of the contracts, and we'd want to know for sure that the individuals who had recently left are indeed working for a competitor. NextGen would also likely be wanting to know whether there was any particular reason for the departures, any issue that prompted it, such as any claims or grievances, or indeed any IP issues that might be lurking there. And I think they'd also need to consider the covenants for the remaining staff and if they would be likely to hold up or be enforceable, and if not, then to take remedial steps to address that.
Yeah, and you'll remember that we had our Mr. Smith who had not yet left, but what type of things could we consider for Mr. Smith?
Yeah, well, Mr. Smith is undoubtedly a key employee as he has almost finished his very promising product. So NextGen Robotics are likely to want to make the acquisition conditional on Mr. Smith transferring, as he is such a key employee, and to keep to sweeten a deal for Mr. Smith, it may also wish to consider putting in place retention incentives. And of course, as part of the deal and the documentation, they'd need to consider who would pay those and when. They'd also want to look at what covenants are in Mr. Smith's contract and whether they are likely to be enforceable or not. And the same as with the robotic staff that have left. NextGen are going to want to protect that promising product, so they're likely to want to consult IP specialists to check who owns the IP rights and to get them transferred to NextGen Robotics as part of the deal.
Yeah, fab. And we heard from the case that there are also some stainless steel production employees at that alloy site. So what would happen to them?
Well, the key question here is, does NextGen Robotics want them to carry on production, or are they likely to be redundant? In which case, alternatively, could Stainless be persuaded to reassign them to the Ironside site before all of this happens?
Okay, and then I guess that gives some more thought around relocation generally. What are those considerations around relocation? And we heard as well about the sort of enhanced redundancy entitlements. Are they playing in? Are they contractual? What impact does that have?
Yeah, so we know that NextGen Robotics has capacity at its existing premises, so that's 20 miles away from Stainless's alloy site and 40 miles away from its head office at the Ironside site. And we know that its workforce has some limited capacity. So if NextGen Robotics decides to relocate the business, then one option would be to agree with employees a change to their location if they are happy to move. Now that would be what we call an ETO, or an economic, technical or organisational reason for changes to terms. And obviously if they weren't happy to relocate, then NextGen Robotics would be in a position where it's potentially having to consider redundancies. Now, the important thing to note about place of work redundancies is that place of work redundancy amounts to an ETO reason, so it's not automatically unfair if the dismissal is post-transfer, but it could still be ordinarily unfair depending on the process. So consideration should be given to whether the dismissal is pre or post transfer, and who holds the liability. NextGen Robotics is likely to prefer Stainless to make them, but they would probably have to indemnify them for the costs. So things like considering a settlement agreement to waive claims against all parties might be something that the parties want to consider. Equally, if, as you say, if NextGen is going to make a relocation or redundancies, then they need to consider whether they're going to be taken over the collective redundancy threshold, and if they are triggered by that, then whether they need to start that consultation pre-transfer. NextGen also have the added issue that they already have an existing robotics workforce, so they might also need to think very carefully about selection pool when they're considering redundancies, because they may need to select from the pool that includes their pre-existing robotics employees. And in terms of whether there's a clause in the robotics employees contracts giving them a right to an enhanced redundancy terms, then that depends on whether it's been set out in a collective agreement applicable to the steel staff, I think, but that could be unlikely. But if it's not contractual, then nevertheless Stainless may want to ensure that the enhanced redundancy terms are honoured by NextGen Robotics, but it's possible that they may have to agree to pay towards that. And there is an argument that even if it's discretionary, then it may still transfer as a discretionary benefit, and then they'd have a duty to act in accordance with the implied duty to maintain trust and confidence. So yes, can get quite complicated in that kind of situation.
And so just on benefits again, so will NextGen be able to replicate the benefits that they're currently getting?
Well, it will certainly have to consider what terms it can and can't replicate. And there may be things, just quite basic things, such as whether it has different payroll dates, a different holiday year, different terms and conditions of any insurance or medical benefits. And, if they can't replicate them exactly, then, what could they provide instead? So I think they need to bear in mind when it comes to this question, they need to bear in mind the potential for regulation 4.9 claims under TUPE, which is where a relevant transfer results in a substantial change in working conditions, which is to the transferring employee's material detriment. And in a circumstance like that, then the transferring employee has the right to treat themselves as having been dismissed and can bring a claim for an automatically unfair dismissal. Obviously, that is a situation where there's a substantial change, which is to their absolute detriment, but it's something that should always be borne in mind.
Just conscious of time, I think we might move on to some of the issues for stainless steel. So what could they be?
Yeah, so NextGen Robotics is a competitor for stainless, so it's possible that they might have some concerns over the confidentiality of the due diligence process even. So steps that they may want to consider in that process could include things like providing for a discrete team to have access to data, to include an obligation to return or destroy documents, to include confidentiality undertakings in an NDA, as well as non-solicitation undertakings. Stainless would also be having to consider whether it needs to make potential redundancies through synergies. Again, because NextGen Robotics is a competitor rather than a private equity bidder, there could be overlap between what NextGen is currently doing, which suggests redundancies could well be possible. And so that they would need to consider that when assessing how long the information and consultation process could take. And again, as I've touched on before, Stainless are going to also want to consider its attitude towards any redundancy plans of NextGen. So who does them pre or post transfer? What about the liabilities? Will they have to work in a collective redundancy consultation? And again, on this point, they're also going to have to consider whether they would agree to a joint consultation of the transferring staff, which, it's not a strict legal requirement, but sometimes the parties do decide to do that, and it can be beneficial. Equally, it can go wrong. So it just depends on the facts and who's involved, really.
And then just on the last question, so what issues, we heard that there was some head office support staff. So what issues should be considered around those individuals? Yeah,
so things to consider about the head office staff are any of them, and I mean by this the central HR, the accounts, are they wholly or mainly assigned to the robotics part of the business? And also, how stable is the workforce? So, are they wholly or mainly assigned today, but not tomorrow? All part of the considerations that Stainless will need to think about whether they should be formally assigned, and if there could be redundancies at Stainless because of that. And in that case, it would be a measure that Stainless would have to inform and consult its own employees about. Equally, on the flip side, Stainless might want to keep some of those staff that would otherwise transfer and cherry pick them or perhaps swap them for others. And in those circumstances, I can imagine that NextGen might want to control or stop that cherry picking so that they, keep who they want to keep in it. So yeah, can be a tricky situation, that one too.
And what I love about TUPE is that you think you understand how things work, and then you get a real live case or a question and you're like, actually, I need to look that up. I need to go and ask someone. So I think the key things to consider here are, there are always going to be issues that come up that you just can't answer by yourself. So please do reach out to your legal advisors to make sure that that you've got all of the information that you need to be able to go back to your relevant business stakeholders with the right answer. So with that, I think we'll move on to some of our top tips to consider when we're thinking about people transfers at a global level in particular, and how to manage some of that complexity just from a more practical point of view rather than a legal point of view. So first up, the main challenge that I've certainly seen in my experience is not engaging with local HR representatives early enough. So often in a transaction scenario, obviously there's a huge amount of confidentiality around what's happening. So that creates a reluctance to get individual countries involved. So things are often done at a global level. The problem with that is that you don't then understand the ER environment sufficiently, because as you know, you can obviously get local legal advice about, you know, what the law says about moving people or consulting people, etc. But actually not understanding how things actually work on the ground, it will only ever give you half the story. You need to know like the history and the context of you know, employee relations issues in that country, and really just the practical steps and concerns of your sort of local HR teams. So do whatever you can to try and get your local HR teams engaged and ready, because the last thing you want is for the whole transaction to be delayed because of a misunderstanding about how long it takes to consult in a particular jurisdiction. Another big lesson that we always take to our clients is around understanding those change impacts. So it could be their legal entity, it could be a change in role, but there could be a huge amount of other things that are impacting employees over the time of the transaction. And I think if you've been to some of our previous webinars, we've talked about very much about the employee experience. And I think really stepping into that employee's shoes and understanding all of the impacts that they're going to face will help you to understand what is actually a big impact versus a small impact. So your impact, changing legal entity, for most people, they're not that interested. It doesn't really make that much difference. But if that's one change alongside 10 others, that might suddenly start to feel like a big impact if you're an employee. And then on that legal entity strategy, so this is obviously decided usually by tax and legal functions, and usually you sort of get a downstream response about, okay, this is what's happening to our legal entities. I think finding out that information as quickly as possible as it becomes available is super helpful. So make sure that you stay close with your tax and legal colleagues and make sure that they understand the impacts that that has on HR. And as Rebecca was saying right at the beginning, you know, the structure of the deal has a big impact on the way that you transfer people. So you really need to understand from the legal teams what is actually happening to that legal entity in that jurisdiction, and therefore what is the legal impact for employees. And then more generally, so you've got your dependencies with legal and tax, absolutely. There are going to be a huge amount of other dependencies across work streams. So if you're transferring people between legal entities, that will definitely have some kind of impact on finance, for example, because people costs will be incurred in one entity, and then another day they'll be incurred in a different entity. So finance will definitely need to know about that. Also, your IT colleagues will probably need to know because it might have access issues with their different systems, etc. And it's best just to double check and just make sure people are aware. And the final point, which is a kind of consistent theme running through all of these webinars, which is about the role of leaders and managers in these processes. So often it is your managers and leaders who are delivering messages to employees about particular changes, and really giving them both the confidence and the capabilities to do that, to deliver messages safely without legal risk, but also to maximize the employee experience, really is going to help make your transaction work and that transfer process go as smoothly as possible. So that is all of our content today. So happy to take any questions if you want to put them in the Q&A box. So Rebecca, I think there's one that you should take if you'd like to get us started.
Yeah, absolutely. Sorry, just doing the classic of mute. Yeah, so the question that we've had is, what are the main challenges you see regarding dealing with the logistics of information and consultation in a hybrid or remote world? Good question. I think one of the key main challenges that we've seen is making sure that the right information and key messages reach affected employees. And we've seen that companies are much more tech savvy when operating in a hybrid environment. And we've seen not only a change in the way that information is being delivered to employees, be that by, video message following a town hall, but a change in the way that the formal information is being communicated to employees. So it's no longer just by, email or letter, but companies do seem keen to embrace technology and use apps and platforms. And indeed, one of the solutions that my colleagues in Deloitte have developed is an information and consultation platform that's aimed at making the I&C process as straightforward as possible. So I think that for me has been the biggest challenge and then solution that companies have found.
Thanks, Rebecca. Megan, I think you've got a question that's probably good for you.
Thanks, Ellen. Yeah, so the question we've got here is, how do we mitigate complexities in a multi-jurisdiction deal? So I think this is a really good question. I think probably the first point I would raise would be back to one of Helen's very recent points around engaging the local HR or ER team. I think that's one of the most critical things to do when we are working across multi-jurisdictions. They're the team on the ground, they're the team that know the local processes and can bring in local legal experts as makes sense for them as well. So bringing them in early on in planning processes is very important. Secondary to that, and I think it's probably both centrally and then through those local teams, would be around understanding the local requirements to either inform or consult, understanding what the processes are locally and what the timelines are, and then it's possible to map out what those processes look like and what the timings look like across the different countries that you're operating in. I think the final point I'd raise there is probably more of a watch out, but just understanding from the business where they might see any cross-country dependencies. So if we've got some global roles where we're either going through a selection process or they're impacting on each other, understanding that so we can make sure we map that into the plan and be aware of those.
Cool, thanks, Megan. We've had another question, which is, what advice would you have for consultation which is multi-year, i.e. not all changes happen at the same time? So certainly this is something that happens all the time. It is very difficult, I think, to get visibility of all of the changes that are going to happen forevermore. And I think trying to get as much visibility as possible and then mapping it out, I think is always a good approach. Certainly when we do sort of large scale transformation programs where we may have different things happening at different times, we try to make sure that we are mapping out all of those changes so that we go to employee representative bodies with all of the changes that are going to happen, particularly if they're sort of pan-European and you've got a European Works Council sitting above your local Works Councils. They would expect to have visibility of changes if you know about them. But there is a definite danger there where you do have sort of multi-year consultations, because things change over time, right? And you need to be able to adapt to that. So it is a very difficult situation to be in. Fab. So I think we'll wrap up there. The final thing we just wanted to gather from you is, are there any other people M&A topics that you would like to learn more about? Please do put something in the chat and we will endeavour to cover that topic in one of our upcoming sessions. I think our next session will be in November, so if you want to hear details about it, please do connect with me on LinkedIn, and I will post out the date and the topic when we have confirmed both those details. Otherwise, thank you very much for joining. It's been a really great session. Thank you very much, Rebecca and Megan, for all of your insights, and we'll see you next time. Thank you very much.